Welcome to our module number 4, first presentation. In this module, we're going to be looking at employment from the very beginning, actually before employment begins, until the end of the employment relationship. As we talk through that, we will be identifying issues relating to lots of different laws that affect that process. In later modules, we'll actually be talking about each one of the statutes separately. So here, let's begin. So I've kind of divided up the employment timeline to talk about recruitment, testing, hiring, then the performance appraisal disciplinary process, and the termination. And usually we're talking about involuntary termination at this point. This first presentation is just going to cover the topic of recruitment. So let's begin. Obviously, in recruitment and all other phases of the employment relationship, an employer can't discriminate. And so as an employer structures its recruitment plans for this particular opening, it needs to think about what are the challenges that are presented that could present some discriminatory issues. And certainly one of the things that the employer is going to want to do is define, if the employer doesn't already have this, what the job qualifications are. Many employers have position descriptions or job descriptions already written for all of its positions, or at least its most commonly used positions. And so under those circumstances, you might want to dust off that position description, make sure it's still current and it's relevant to the particular opening that exists. If you've got that, great. But if you don't, you'll want to think through, what does this person really do? I mean, you might want a brain surgeon to do this job, but is that really necessary? Does this person actually cut open, people's skulls? If they don't actually do that, you probably don't need a brain surgeon. And so you want to think about, what does the job actually require? And then once you know what those skills are, those tasks are, then you can decide, well, what skills are necessary to support the effective performance of those particular tasks. And then, of course, you're going to be thinking about, how do I find those people that meet these requirements? And again, eventually we'll be talking about interviewing and reference checks and things like that. But again, in this presentation, we're focusing on recruitment. Okay, so these are the issues that we're going to talk about as we talk about recruitment. And as we go through each one of them, we'll pause and discuss it. Our first one is, of course, discrimination in the recruitment process. Obviously, recruitment is the very first step. And when I use the term recruitment, what I'm talking about is identifying, finding candidates or letting candidates find you. At this point, you're not whittling down your list of candidates. You're certainly not hiring anyone. You're just getting that stack of resumes together. And so you may think this is a relatively safe time because you're not ruling anybody out. But if you recruit in certain patterns, you are effectively ruling some people out. And we'll talk about how that can arise. So definitely recruitment is an area of the law that directly arises, the recruitment is a topic that directly arises in the context of employment discrimination law. I've named a few statutes here, but this is not an exhaustive list by any means. We could absolutely add Americans with Disabilities Act and other statutes in this area. But these are just some examples of ones that are certainly relevant as we talk about this issue. So federal law requires that employers think about how they're going to recruit in a way that will attract diverse applicants. In other words, the goal is not to have only white men applying for the position. And so thinking about, well, how can we attract that diverse population should be one of the factors that the HR department is considering. If a company isn't smart about this and only attracts people of a particular race or a particular religion or a particular gender, and the EOC becomes aware of that, then what the EOC might do is say, well, as we looked at it in the Hazelwood case, what is the population of qualified people in this community? And let's say that population breakdown is 50% white, 25% Hispanic, 20% African American, and 5% Asian. But let's say the applicants are 90% white, 5% Asian, 2% Hispanic, and 3% African American. Well, you can see that this firm has not done a good job at getting a diverse pool of candidates, and that certainly could be some evidence that the employer is discriminating against individuals who are not white. So most employers don't study these statistics closely, but if an employer were to see, I mean, you have a sense as to what your community is. You may not know these numbers exactly, but if your sense is these are what the numbers are, and yet you draw applicants like this, you ought to be very concerned. What's going on here? Why am I not attracting all these awesome and qualified people that are diverse? How can I be smarter about doing this? And of course, the tools that the firm uses to recruit are what lead to what this population looks like. It's not a, oops, how did that happen situation. It's conscious choices that that company has made. And of course, if it's a conscious choice, then another choice can be made to correct the problem. Some states actually have more detailed laws about recruitment. Texas does not have those types of laws, so we don't have a particular issue in Texas. We're also going to talk about common law recruitment violations, specifically fraud and misrepresentation. We talk about those later on in this presentation. And so we'll talk about, in addition to discrimination and immigration issues that arise in the recruitment process, we'll discuss briefly common law. Okay, so now we're going to discuss the recruitment methods. These are the methods that can cause you to get one of those lopsided results where you seem to be attracting only a narrow sliver of the qualified people. And not only is that a discrimination issue, and it certainly is that, but it also means you're losing out on lots of qualified people that might be your best candidates for the job. So it not only is possibly discriminatory, it also means you're not getting access to the best talent, which obviously can ultimately affect your bottom line. So here are kind of the categories of recruitment practices that can exist. Obviously, advertising. This can be in the newspaper. Once upon a time it would have been, more likely on the internet. It can be through word of mouth, telling your current employees to let their friends and family know about it. It can be promoting from within the organization. This historically has been very popular, and there's lots of advantages to this. And I'm certainly not going to say it's a bad method, because every organization does some of this. If you didn't, you'd have real morale problems in your place of employment. But having a culture that was completely promote from within is not always the best. And let me talk about that in a little bit more detail. When I was at JCPenney for the first, I guess I was there for 17 years. For the first 6 years, it was almost an extreme example of promote from within. Every CEO the company had ever had been hired as a management trainee straight out of college, or even when they were in college. The only people that were hired later in their careers were people, certainly sales associates were hired in the press, but I'm talking about management folks here, or people in specialized fields like attorneys and accountants and people like that. It was very rare for somebody to transition to, for example, to be hired as a store manager at a penny store. And that almost never happened. And a few times it did, it was because of unusual circumstances, usually in remote places. And so one of the benefits to that is that people who were employed there felt that they had a good chance for advancement. And when somebody did get a promotion, at least there wasn't maybe the bitterness that sometimes happens when someone from the outside is brought in. Another advantage, and this is also a bit of a disadvantage, but it's also an advantage, is that people knew how to maneuver in the culture. The culture was communicated consistently, and it wasn't changing really, because people were raised in that culture and they continued that culture. So there were lots of good things with respect to it. But some negative things were, especially in smaller markets, is that sometimes the best candidates weren't the ones promoted. It might be that there weren't any managers who were in that area who were willing or able to take on that responsibility. And so the person who was promoted might not have been the best that the company could have found. Perhaps hiring from someone outside the company, maybe someone who was managing a Walmart or a Macy's or a Sears or something like that would have been the better candidate for it. So sometimes the best isn't within your organization. A third problem that can happen if you promote from within is that you don't learn best practices from other companies. JCPenney's for many years was this very smartly run company, but it doesn't mean that every single awesome idea that exists was present in JCPenney. So if Penny had hired people from Kohl's and other places, they would have said, oh, wow, that's a great idea. We didn't think about that. Or, yeah, we see how that could work. Thanks for that insight. Getting new ideas and new energy into a place can be very effective. And that's one of the reasons why diversity in a workforce is important. We oftentimes think of diversity as including women, including minorities, but including people from outside the culture of the organization can be another really important source of diversity. Anyway, so JCPenney, at about 1998, 1999, went to start hiring people from outside the company. And by the time I left, after I'd been there 20 years, 17 years, most of the people in senior leadership were not people who had been, quote unquote, raised in JCPenney. Most of the store managers, and even not all the store managers, but most of the store managers had been, but in the higher levels, they were oftentimes from other retailers. And so that was a real change in the culture in terms of promoting from within. And the fact that there were these diverse people from diverse experiences changed the overall culture of the company in some ways that were positive and in some ways that were negative. So promoting from within is a cultural choice. Probably the best answer is having a combination of promoting from within, maybe having that your default setting, but also recognizing there is some need to bring in from outside. Venue recruiting would be like job fairs and things like that. That's especially effective when you are recruiting entry-level management, perhaps having college fairs, or when you're hiring people who are going to be your line workers, your sales staff, your blue-collar workers, people along those lines. Walk-in applicants can also make sense. You certainly want to be open to those populations. And, obviously when you use one of these tools, you're not excluding the other tools. You may focus on advertising, but if somebody walks in, you're going to take their resume. So this is probably one that you almost always are going to use. You're almost always going to promote some from within. You're almost always going to have at least some applicants. Neutral solicitation, this would be, when you are communicating that, putting the word out generally in the community. Lots of different methods. It could be social media. It could be, I guess you could say it's kind of a broad term for lots of these different tools. So a smart recruiter isn't going to focus on just one of these. And he's not or she's not going to advertise just in a place where people of a particular ethnicity or gender are going to be paying attention. So let's look at some of the problems with some of these approaches. So if you're posting some kind of want ad on social media or on a internet site or some kind of announcement posted on the board in your office, you want to make sure that you're using very neutral language. Certain words can have a connotation about them that may not be intended, but can have that take to it. And I have some examples on the next slide. If you're using an employment agency, and that's a good example of a neutral solicitation situation, you want to make sure it's an ethical agency, and you want to make sure that they understand that you don't want any type of discrimination. Nepotism is a vocabulary word. You perhaps know it already, but if you don't, it's when you favor relatives. Generally speaking, nepotism is okay. If I run a small restaurant, say, I'm probably going to staff it with my family members because those are the people that are available to work. So it's not per se a violation of Title VII or another law, but obviously if they're relatives of yours, in most families, they're not going to be that diverse from you. I mean, obviously there are some families where that may be true. So it's not unlawful, but as your business grows, at some point, number one, you're going to run out of relatives, right? And number two, you're going to want to start thinking about, does my workforce reflect the diversity in my community? Word of mouth is also an approach that virtually everyone is going to use to some extent. After all, your employees can talk up your company and can tell you who would be a good worker and who wouldn't be. So it is a smart tool, but you don't want it to be your only tool, because guess what? If you have a workforce that, say, is strongly, or we'll say 90% white, well, most of their friends and family are also going to be white. And if it's only word of mouth, then that means that the only people hearing about the opening are going to be white people. And so all of the awesome people who might be people of color in the community aren't even going to know about the opening. So yes, word of mouth is one good mechanism, but I wouldn't use that as my only mechanism, because you're not getting access to everyone. So here are the terms that I talked about before that might appear in one ads that are dicey to use. Draftsman, again, we have this word man here. Sales girl, again, it suggests a particular gender and maybe a particular age. Repairman, paper boy, an age and a gender. Maid, again, suggesting female. So better to say a draftsperson, a salesperson, a repair person, a paper deliverer, a janitor. All of those would be better terms. You also want to avoid language like recent college graduate. I mean, it's true that people at various points in their lives can graduate from college, but most people graduate in their 20s. And so that implies we want somebody who's in their 20s or early 30s to work for us. So that would suggest that you don't want to have older workers. And so that could be interpreted that way. Let's consider this scenario. Chez Robert is advertising for waiters. Waiters wanted, experience required, must look good in tuxedo. That must be what the waiters at Chez Robert wear. Well, again, a tuxedo is usually a garment that a man wears. Mary has experience in five-star restaurants, so she meets the first requirement here. She thinks she would look okay in a tuxedo, but she also gets the vibe that maybe they don't want women to be waiters there. Under these circumstances, because of this must look good in a tuxedo language, Mary might well have a claim for gender discrimination if she isn't hired. Let's consider the issue of foreign nationals. We'll talk more about immigration issues later on in this course. This is not an immigration course by any stretch of the imagination, but let me pause here and talk a little bit about the relationship between labor and employment legal professionals and immigration professionals. In my experience, it's very common when the the employment law professional is in-house, meaning he or she works for the corporation, for him or her to hire the immigration attorney to handle immigration matters. So in this sense, the labor and employment legal professional is the client and the immigration attorney is the attorney. So it's not unusual for the employment law paralegal or the employment law attorney to also be the representative of the client. That happens pretty commonly when there's employment litigation, especially when the legal department is relatively small, and so matters that result in litigation are farmed out to law firms. And so then when issues come up in the case, the law firm contacts the labor and employment department within the legal department of the corporation. So it's kind of interesting. In many respects, your job as a legal professional is to be the client. Kind of an ironic way of looking at things. But again, that relationship with the immigration attorney, it's relatively rare that a labor and employment legal professional is sufficiently knowledgeable about immigration law to actually serve as the immigration attorney. But we as labor and employment legal professionals oftentimes are asked to know enough so that we can educate the client and so that we can be a smart consumer of immigration services. Okay, so let's consider. Obviously, when somebody is a foreign national, that means they aren't a citizen of the United States, obviously. And so if they do not have permanent resident status, in other words, they don't have a green card, which actually isn't green, but you get the concept. They have to obtain a visa in order for them to be permitted to work in the United States. And here's a definition of visa. So a visa is a document or official endorsement obtained by a U.S. consul who allows its holder to apply for entry in the United States. Here are 4 examples of visas. In my experience, H-1B is the one that I've dealt very significantly more commonly with than all the others. But depending upon your practice area, you may find that a different specialty is more relevant to your area. H-1Bs are really only for kind of the cream of the crop category folks. And so many people who a particular company might want to support for a visa aren't really going to be eligible for the H-1B. So what happens when a company decides that it wants to hire, Susan, who lives in France, is that typically the employer is the one who hires an attorney in the United States who's an immigration attorney to facilitate the paperwork. Obviously, Susan's involved, but she's going to have to provide information and do some legwork on her own, but the legal fees are going to typically be paid for by the company. Now, many times when people talk about immigration law, they are thinking about people who might be wanting to come to the United States because of difficult times in their home countries. And certainly those are oftentimes very, very compelling stories. That's not the type of immigration that we're talking about here, though. These are not people who are economically disadvantaged. In fact, many times they're quite wealthy people. And so it's not that type of situation at all. Temporary workers can come up in touristy areas where you have a high season for tourism, and there just aren't enough workers to be tour guides, to be janitors and hotel clerks and things along those lines. So in certain industries, those can make sense as well. Let's be a little bit more granular. Again, here's some more information about the H-1Bs. Okay, so the number is capped, and so as a result, you want to get those applications for the H-1Bs in early in the year because very likely the number will be filled up, and then you'll be pushed into the next year. The position, the incumbent has to have a bachelor's degree at least, can have more than that, oftentimes does have more than that. And the person can only work in the U.S. for 6 years. So many times these are in the computer area, although they don't have to be. I worked on one when I was at JCPenney where the candidate was British, and her specialty, and I found this funny at the time, I still do kind of, her specialty, what made her so exceptional was that she designed bras. And something about the way she designed bras that made them really, really, I guess, comfortable. I guess that was the idea. Anyway, I always wondered why we needed somebody from Great Britain to design a bra, because it didn't seem like the technology was really that difficult. But in any event, we applied for that person and we were able to get that visa approved. So it can be all kinds of different areas where we see the visas come up. We've already talked a little bit about the H-2 visa. Again, one of the things that has to be shown is that there aren't enough U.S. workers to fill those positions, and that if you have this influx of foreign workers, it's not going to push down the wages of the U.S. workers who are already there. So again, for certain industries, this can be a very significant part of the employment situation. L1s are when a company that is in more than one country wants to move folks around. So let's say you're Exxon and you've got offices all around the world, and there's somebody in South Africa that you feel would be perfect to work in the Irving, Texas headquarters. And so L1s allow you to move folks around to some extent so that you can meet your business needs. Obviously, labor trafficking is a terrible problem. We learn more and more about this as the years pass. And of course, it is the recruitment, the harboring, the transportation of people through some type of force or coercion. It's obviously a crime. It's a crime here, it's a crime in other countries, and it's probably much more common than any of us realize. One of the things as you are working with recruiting foreign nationals and using sources of labor, especially if you are in this bucket where you're looking at H2s, a smart employer is aware that sometimes these individuals might be in difficult positions, so it's always important to be aware of the circumstances and the people with whom you are working, that you are using to recruit these individuals. So let's talk about the application process. And here are some important decisions need to be made. How are you going to structure that? What is going to be on the application? What type of information are you going to ask to be included in the resume if you don't have an application? How are you going to do the interview? Will it be at the time the person drops in, if you happen to do stop-in visits? What type of questions will be asked? How many people will they interview with? How long will the interview process go? What are you going to do in terms of background checks and reference checks? The reality is that it's very common for there to be significant inaccuracies in resumes. I read somewhere that 1/3 of all resumes include not just exaggerations, but complete fabricated facts. And so smart employers do some confirming of information on resumes. And of course, it can even make sense to do background checks. That's going to vary from industry to industry. I'll tell you a story that a retailer that I'm familiar with had a situation not in Texas, in a different state, and that retailer did do background checks on its sales staff before it hired the individual. And in this particular case, the candidate for the job came back as a sex offender. He had been convicted of inappropriately touching his, I believe it was his granddaughter. It was a child, and he was convicted of that, and he was a registered sex offender as a result. He wasn't scheduled to work in the children's department, but this was a small store, and children would be with their parents at all kinds of different places in the store, not just the children's department. And sometimes parents would leave their child unattended for a time, maybe say, oh, Sally is having fun over there, we're just going to go look at the drapes or something, and might not be watching their child every single minute. Plus, sometimes there would be somebody who would be out because they were sick, and so maybe a particular department might be short-staffed, and so people might need to be moved around to support another department. As a result, the store decided not to extend an offer to this man because of his conviction for inappropriate touching of the minor. Well, the man filed a charge of discrimination in that particular state, and that state had a a provision in its laws that said you couldn't discriminate against people based upon their criminal background, except if it was reasonably related to the job. And we felt we had a really good defense because, after all, we were a retailer, and there were children that would naturally be in this place of business. Well, the state said, no, you could just bar this particular worker from talking to any of the children or working in the children's department. Well, the problem was we couldn't supervise him at every moment. We couldn't be certain that he wasn't talking to children. And if he did somehow or another inappropriately touch a child, obviously that would be huge trauma for that child, huge trauma for those parents, and also a tremendous amount of liability for the company. And so this particular retailer was darned if it did and darned if it didn't. The state was telling it that it was going to sue the employer if it didn't hire the sex offender, but if it did hire the sex offender, all kinds of bad things could happen as well. Ultimately, the issue was resolved, and the sex offender was moved to a role that he would have no opportunity to interact with anyone under the age of 18, and we were able to resolve the issue. But you can see how difficult some of these issues can be. Now, if we hadn't done background checks at all, we might well have hired this man without being aware there was even an issue relating to the safety factor. And that kind of falls under that negligent hiring idea. If we hadn't done the background check and we are putting this particular employee in a position where he or she is interacting with the public, and then he or she does something harmful to the public, and if it turns out that if we had done the background check, if we had checked the references, if we had done the criminal background check, we would have known about whatever that aspect of his or her personality was, and then we would have decided not to hire that person. Well, we could face a claim of negligent hiring from the victim. And those types of claims, those are tort claims, those types of claims have typically unlimited damages. So it could be a huge, huge cost for the company. So as we consider that application process, the employer has to decide how does the applicant actually apply? Does it need to be an application that's filled out? Is a resume enough? Do I need both? Maybe I want a writing sample as well. Maybe I want a list of references. Maybe I want a work sample, depending upon the industry. Another issue is, how long do I keep applications? Do I keep it for 90 days? Do I keep it for 6 months? Do I keep it for 30 days? When do I start accepting resumes? Do I accept them 365 days of the year? Or are there only certain times of the year that I accept applications? All of those are decisions that should be made before you actually get that first resume, so that no one can argue, well, you came up with that role simply because I applied. You decided you were only going to consider resumes for 90 days, but you made that decision after I applied. Well, it's better to have an approach to those answers from the very beginning, so that there can't be any issue that you are treating people inconsistently. So when you, whatever the standard is that you have, is that you want to keep the applications and any related records, such as notes from the application or resumes or writing samples or all that stuff. You want to keep that for at least a year after the hiring decision is ultimately made. Now, for the individuals you actually do hire, you have to keep all those records for at least a year after their employment ends. Now, you don't have to keep it necessarily in paper format, and you can keep it in some electronic format, but you do need to keep those records. In some cases, especially if this is a federal contractor, you're going to have to keep records about the ethnicity and gender of the people who apply. I once had a situation where I was responding to a charge of discrimination, and I got a stack of, or actually I was, and as a part of that investigation or that discrimination charge, I was looking at various personnel files of several people who worked in that facility. And I noticed on the applications that in the corner, written very lightly in pencil, was either the word W or B. In this part of the country, there weren't very many Hispanic or Asian people. Most of the people were either white or black. And back at this time, black was the more common term. African American wasn't as frequently used. And so it was pretty obvious that this was a way to identify the race of the candidates. I was very concerned, to put it mildly, that this particular employer had been trying to identify, when, for example, maybe when the clerk who accepted the applications would, obviously notice the race of the person who was submitting the application and then provide this information. So I was concerned, was doing this so that the manager could say, oh, well, we only want to hire the white people. And so he would be able to sort the black applicants out of consideration. Obviously, immediately when I saw this, I alerted my manager to say, I don't know what's going on here, but this is bad. And he was concerned as well. So we had a series of meetings, and I ended up talking. And actually, these events had happened. These candidates that I was working with had actually been hired, I don't know, 10, maybe even 20 years earlier. So the people who had actually been involved in writing the B and the W on the applications, I don't even think worked for the company anymore. It was, events from a long time ago. But so we were trying to figure out what had happened, and we wanted to make sure that there wasn't any overt or covert discrimination happening. Anyway, we ultimately discovered that this was an initiative from the EEOC, that we had done all of this coding because the EEOC had asked us to track our list of candidates for a survey that they were doing to see the various labor pools in various markets. So it was completely legitimate. But this is an example about how institutions exist way longer than the people who are doing a particular action might be around. And so something that looked very awful ended up being completely innocent and didn't indicate a problem at all. So you have to keep that in mind. It's always a good idea to make it clear in the records exactly what you're doing and why you're doing it. Because again, in 10 or 20 years, you might have gone on to something bigger and better, and the company is trying to figure out why you made the choices that you made. So let's consider the term applicant. We all kind of know what that means because it's an everyday word. It's a very broad term, and it can be interpreted in a variety of ways. But generally speaking, it's any person who indicates an interest in being considered for the position. And again, this is a specific position. So if I send my resume to Exxon and say, hey, I'm applying for anything you have, I'm not an applicant. But if I say I'm responding to your internet ad for a junior systems engineer in your ABC department, then I have become an applicant in that basis. So it does need to be focused on a particular position, but within that category, once I have indicated that interest, I am now a candidate. Sometimes we want to be more granular and talk about internet applicants, because obviously this is a very common way nowadays to apply. And naturally, that's an applicant who expresses the interest through the internet. So is found out about the job or is posting his or her application through the internet. Let's consider pre-employment inquiries. Obviously, an employer or potential employer wants to get information from the candidate to decide whether the candidate is the right person for the job. And so there's a very legitimate interest that the employer has, but it can be perilous to ask questions of the candidate if you don't know where the lines of demarcation are. I would say if you were to ask me, what is the one thing that corporate America does not do a good job with, and that is training its interviewers what the rules are about what's lawful questions and what's unlawful questions. In many corporations, the people who conduct those interviews are perhaps not even in management, and if they are in management, are in a relatively low-level management, and so have received relatively little training in what's lawful and what's unlawful. So they oftentimes make mistakes, again, not because they want to do it wrongly, but because they haven't been given the tools to be successful. So obviously the first one's a no-brainer. You don't ask people, what's your race? How old are you? Where do you go to church or synagogue? Those questions clearly are prohibited. But sometimes innocent inquiries can cause you to go down that path. Let me give you a couple of examples. Imagine that you're trying to make small talk. I call this, when I would train people at JCPenney, it was a pretty big part of my job. I would talk about the most dangerous time in a job interview was the walk from the reception area to the interview location. I don't know if you've ever been to the JCPenney facility in Plano, but it's not very many floors tall. It's only 3 floors tall, but it's very, there's a far way to walk on any one level. And there was a central place where candidates would go for reception area to kind of be interviewed, and then they would be taken oftentimes to the department. So you might end up walking 10 minutes with that person to get to the interview spot. Well, it's kind of an awkward thing. You kind of want to make that person feel comfortable, so you kind of engage in small talk. You might talk about the Cowboys, you might talk about the weather, but a lot of times things drift in a lot of different ways, and so you oftentimes start talking about them. Well, I'll give you some examples of problems that sometimes came up when people engage in the small talk, and I sincerely believe in each one of the cases I'm about to share with you, there was no evil intent at all. So one of the things about JCPenney, when I worked there, that made it very popular was that there was a daycare center, a very excellent daycare center that was on site. And it was very popular because you could have your children close to you in a safe location. You didn't have another drop-off to do. And so many times people would be interviewing and they would walk close to where, as they were taking the interviewee to the place that the interview was going to happen, they would walk close by the place where the daycare center was. Or maybe they might even see the toddlers and preschoolers walking around the building because they would have various field trips around the facility. And so what has happened is that the interviewer would be trying to sell JCPenney's person, say things like, oh, we've got this great daycare center, lots of our employees really like it, and it's one of the big attractions to our place of employment. And then, to kind of include the interviewee in the conversation would say, do you have any children? Do you have any preschool children? Do you have an interest in learning more about the daycare center? And all those questions were innocent, and yet they were potentially problematic because it's really none of our business whether an applicant has children or whether an applicant has children of a particular age or whether an applicant has an interest in daycare services. But you can see those questions could be interpreted to find out whether this person might be going to be missing work because he or she has a young child, or it could be used to kind of figure out how old this person is. Obviously, 60-year-olds probably aren't going to have preschoolers. It could also be used, or it might be a question that was focused on only the female applicants and not the male applicants. Another way that it can come up is when you're in the interview and you're looking over the resume, you might notice, oh, this person went to the same college that my brother went to, or my second cousin went to. And so you start saying, oh, did you know, Bob Smith, my cousin? And if the person says yes, well, then you kind of, you know how old your cousin is, so now you kind of know how old this person is, right? And if the person doesn't know your cousin, then a lot of times it says, yeah, I think my cousin graduated about da-da-da year. And then that's kind of an invitation for the other person to say, oh, I graduated 5 years before then or something. Well, typically the year that you graduated from college is a pretty good indication of perhaps how old you are. And so all of those are inappropriate areas of inquiry. As a result, I used to say that's the most dangerous part of the interview, that trip to the office when you're trying to make small talk. So just be guarded when you're talking about that information. You don't obviously want to ask about the date of graduation, membership in organizations that might tend to provide information, like membership in religious organizations or culturally specific organizations. You don't want to ask about any kind of workers' compensation records. Here are examples of bad questions to ask and better ways of asking it. So we're not going to ask the date of birth, but we can ask, are you at least 18 years of age? That is almost always going to be an okay question in Texas. I would tell you, though, that there are a few states that may not be completely okay. For example, in Florida, you can't discriminate against people even when they're younger than 18 for positions of employment. Now, you can prefer people who are more experienced, and obviously if you're 16 or 17, you're not going to have a lot of experience. But you can't say I prefer an 18-year-old over 16-year-old as a general proposition. Most, of course, under federal law, age discrimination applies to only people age 40 and older, and that's the rule in Texas as well. Even in states that do have some kind of reverse age discrimination claim, meaning people who are especially young are protected from discrimination, usually that does not extend below the age of 18. But again, Florida don't do this, but in other states, it's a safe question. We don't ask about whether a person is a U.S. citizen, but you can ask, after being hired, will you be able to document your eligibility to work in the United States? Another way of saying this that I've seen used to great effect is to say this: we won't be sponsoring successful candidates for visas as a result of this position. So you will need to have your own visa if you are not otherwise eligible to work in the United States. And then you can ask this question. The key, though, is you have to ask this question for everybody, even the person who has an American accent and who seems to have been born in the United States. It's kind of a weird thing to say. They're going to be like, what? No, I was born down the street. But you need to be consistent, because you can't assume, obviously, that somebody who has a foreign accent is not eligible to work in the United States. Another approach in this area can be to put up a sign when you do the interviews, especially if you're interviewing on a college campus or something, and that sign can provide that same information, putting it in a place that every single candidate can see that. Are you available to work on weekends? I think that this is a fine question, so I'm going to put this in the advisable category. You only are going to want to ask that question if your business requires it. If it's if it's a Monday through Friday 8 to 5 job, this wouldn't be a good question. And I don't think that you need to volunteer that you're going to accommodate religious practices. That is a legal requirement. You will have to do so, but I don't think, unless that the applicant raises the issue, that you need to start talking about that issue. Have you ever been arrested or convicted of any crime? You don't want to talk about arrests The reason for that is that the statistics are quite clear that certain minority groups, especially males in those groups, are more likely to be arrested than members of other groups would be. And of course, being arrested doesn't mean that a person is guilty at all. In fact, arrest really shouldn't be considered in the process. We ought to look only at convictions, and only convictions that are reasonably related to the job that we are filling. So a conviction should not automatically make you ineligible to work. Speaking of that, let me give you an example of a conviction situation. So this individual applied to work at a business that was not, it was not a business that was a retail store, but it was a business where confidential information about the business's clients would be available to this particular individual. He shouldn't have been hired, probably. This was probably a bad interview process, but he was hired. And, or I guess he was extended an offer, and then the criminal background check came back. And it was discovered, and at that time, this particular employer had a question on its application. It's very common wording. Have you been convicted of a felony in the last 7 years? And he said no. And then we did the background check, and in fact, he had not been convicted of a felony in the last 7 years. The reason he hadn't been convicted of a felony in the last 7 years is because he had been in prison for the last 20 years. I think it was 23 years. He was in prison for murder. 23 years ago, he had been convicted of murder. Well, since he was in prison, he hadn't been convicted of any other crime, but he had just been released from prison in about the last 6 months. And so he really hadn't had a long period of time of showing that he was a reformed individual. And certainly, given the nature of the crime, it was a concern to have him working with our other employees and also having access to confidential information about our clients. He fought when he was not actually extended a permanent, or he wasn't allowed to start working. He filed a claim, and again in that state, it was a different state than the sex offender situation. This state also had a rule. It wasn't a statute, but it was a guidance from its state agency that you shouldn't consider convictions that were more than 7 years old. And again, this gentleman had not lied on his application because, after all, he hadn't been convicted in the last 7 years. Our position was he needed to be free and kind of available to commit crimes for 7 years before that 7-year window should have closed. We were successful in that case, but I don't know that we would have been successful in every state. So that does raise kind of a complicating factor. Most people use 7 years in terms of the look back for convictions. But if a person has been continuously incarcerated for the most recent 7 years, then I think it's reasonable to not start the 7-year clock until the person has been released from custody. But again, that's going to be a decision for the client to make ultimately after he or she has weighed the risks associated with the particular crime. Let's go on to the next one. So again, you want to make sure that when you discuss requirements for the job, you discuss those with every single candidate. It's kind of good to have a script. I don't mean this in a too strict of a way, but a list of things you're going to tell every single candidate and not to vary from that list. Again, you don't want to ask about prior arrests. You don't want to ask about weight or height. Those questions can indicate possibly disability, or I guess with arrest, since African American males are statistically much more likely to have arrest record even when there aren't convictions than Caucasians. Those are questions that are smart for the employer to avoid asking. We also can't ask medical questions of candidates until after we've decided that we want to hire that person. We have something called a conditional offer of employment. Let me skip ahead for a second here. What is a conditional offer of employment? It means that the applicant will be hired as long as he or she passes a medical exam. So you're basically telling the person it's a done deal. You got the job as long as you pass this test. So you need to refrain from asking those questions. And you have to have all applicants, even ones whom you do not think are disabled. So you don't want to ask about mental or physical conditions, medical history. You don't want to ask about workers' compensation claims. Now, sometimes you will have candidates that volunteer this information, who say, I will need a place to store my insulin because it needs to be refrigerated, or sometimes it's just obvious because the person's in a wheelchair, or the person has brought a sign language interpreter for him or her. So sometimes you become aware of the issue, the medical issue, simply by the person showing up at the interview. Now, sometimes you will know beforehand because the person will tell you, well, I'm going to be bringing my sign language interpreter, or I need a sign language interpreter. And so you're kind of prepared at that point. But sometimes you don't have any preparation. The interview is going fine and the person volunteers, I have schizophrenia in the middle of the interview. Or the person comes to the interview and the person's in a wheelchair. And so then it really falls on that interviewer and on the preparation the interviewer had to know how to handle those questions. And so again, that's where we get into the tricky situations where the person is just not expecting that these issues are going to arise, and yet they do without having the ability to prepare beforehand. Now, even when the person is obviously disabled, you can't ask them how they became disabled or how that will affect their job. But what you can do, and again, this is something that the interviewer has to be coached carefully on, and it's a good idea to give them actual language so they can actually read it, so they'll be prepared if they do happen to encounter a candidate in this position. And that would be to say, how would you do this aspect of your job? Please demonstrate. Now, if you do this for one person, you ought to do this for all candidates. So it's a good idea to be consistent in how you do that. If you choose to extend conditional offers of employment, you need to do that for every single candidate. So you can't ask the disabled person to submit to a medical examination, but able-bodied people don't have to have the medical examination. So you have to have a hard and fast rule in that area. Most positions do not require a medical examination, but there might be some, that the job is especially demanding or especially high risk. And so for those positions, you need to think very carefully through, number one, what type of exam that will be, who's going to conduct it, how are you going to communicate that to the candidates. And again, during those medical inquiries, sometimes you learn about disabilities that you may not have been aware of. I've even heard of times where a doctor diagnoses something that the candidate was unaware of. And obviously that information cannot be used to the detriment of the candidate. Now, if the person cannot safely perform the job because of the disability, then obviously you're not going to hire them. It's conditional based upon the successful completion of the medical examination. For example, imagine there's a job that oftentimes requires the climbing of ladders. And during the medical examination, the doctor determines that this person has a significant case of epilepsy, and that it is not the type of epilepsy that the candidate knows in advance when he or she is going to have an epileptic event. Well, if the person is on the ladder, very likely the person will fall from the ladder, could severely injure himself or herself, possibly kill himself or herself, and possibly injure somebody else who's on the ground. So under those circumstances, it would be appropriate to withdraw the conditional offer of employment. Hopefully, you'll be able to figure out some other position in the organization for which this person can safely perform the job. Obviously, epileptic people can perform the vast majority of jobs, just not jobs involving climbing a ladder. So let's talk about social media. Social media is commonly used by employers. Certainly not all employers use it, but it is commonly used. Looking at an applicant's Facebook, Instagram, Twitter, and LinkedIn are common ways of finding out more about the candidate. Some employers require to get passwords to those various accounts so that they can see information that might not be visible generally. Other employers just see what they can see visually through just Googling and surfing. Some states have limited the ability of employers to do this type of research. At this point, Texas has not done so. That obviously can change, so you want to be sure that you stay abreast in this area. Obviously, the information that the employer can get can be a two-edged sword. For example, the employer might find out that a candidate is gay, and of course that is now a protected category, and so that particular potential employer may not have had any way of knowing that this candidate were gay. Well, if the employer decides to pass on this candidate now, not to extend an offer, then the candidate might say, well, the only reason you didn't extend me an offer is because you found out I was gay when you checked out my social media. So you can see how sometimes employers don't want all the information. On the other hand, if the candidate on his Facebook feed is constantly talking about getting, super drunk every weekend, and there's pictures of him smoking something that doesn't look like a cigarette, you could say that an employer would be wise, perhaps, not to consider hiring this person because of maybe some dangerous activities that they may be engaged in. So there are pluses and minuses with respect to those types of ideas. And part of what's probably most employers do is they use social media for certain positions. I mean, if you're hiring someone from CEO, you need to know a lot about that person. If you're hiring somebody to be a janitor, it may be less important that you know what is on their social media. Now we're going to look at statements made by the employer and what are the risks there. Mainly we've been talking about what the employee is sharing and what we're asking as an employer. But employers also make statements. They oftentimes try to sell the applicant on the position, talking about how wonderful the work environment is or how wonderful the job is. Well, these statements do have potentially the possibility of having legal consequences. And so if you do not, or if you share inaccurately positive information, then it can be that candidate reasonably relies on it. Remember we talked about promissory estoppel during an earlier lecture? Let me write that up here. And that is, you may recall we talked about how the promisor makes a promise, and as a result of the promise, he is estopped or stopped from not fulfilling that promise. My handwriting really is better than this. It's hard to write with a mouse. So if you say to a candidate, well, I think we're offering $15 an hour for this job. And so the person accepts the job ultimately, resigns his current job where he earns $14 an hour. He shows up on his first day of work and he's told, actually, no, the pay rate is $12 an hour. Well, that worker, quite reasonably, is pretty ticked. Wait a second, I was earning 14. I can't afford a $2 an hour pay cut. You told me I would be earning 15. And so under those circumstances, there's an argument that perhaps the employer should pay the $15 an hour. Now, of course, the counter argument is that the employee is employed at will, so every single minute of every single hour, the employment relationship is renewed. So I guess you could argue, perhaps for that first hour of employment, that employee is entitled to $15 an hour. But once the employer communicates that the pay rate is going to be $12 an hour, then the employee has the right to continue at $12 an hour or can resign. I'll tell you, the usual answer is going to be in Texas that employment at will is going to control. Maybe the court might give the person more than an hour of employment at the $15 an hour, but it won't be a long term. Okay, you can work at $15 an hour for the next year or whatever. Fraud can be an issue, and a fraud is a tort. This is not technically a tort. Actually, this is in the area of quasi-contract. So it's kind of like a tort. That's probably the better example to use. But you're not responsible for knowing this. It's a cross between a contract and a tort. But fraud is clearly a tort. And in this case, this tort has to do with the employer misrepresenting a material fact. When we use the word material, we mean important fact. A fact that would have caused the person, the applicant, to say, wow, that's important. That could be a decision maker for me, that particular information. And certainly wages and hours and things like that are material facts. So it's a misrepresentation of material fact with intent to deceive or recklessness about its truth or falsity. So if I'm doing the interview, I throw out $15 an hour, I don't have any idea what the actual pay rate's going to be. That's not what I do. I don't focus on establishing the pay rate. Well, then I may well have engaged in fraud, assuming that the applicant reasonably relies. Well, if the interviewer gives me that number, I think it's pretty reasonable for me to think that he knows or she knows what he or she is talking about. And here are the elements of fraud. Again, this definition applies in more than just the recruitment situation, but it certainly applies there. So it's a false representation of a material fact made to another person. Party knowing the fact knew it was false at the time or recklessly disregarded the truth, didn't do reasonable research to find out the truth. The party intended for the other party to rely upon the information. The party actually did rely upon that information, and the party was harmed. In our example, we satisfied all of those elements, and so there was the potential that this could be a fraud claim. So again, but you have to balance it with that employment at will. So it can be a difficult case for an employee to win, but of course, it helps no one to engage in fraud under these circumstances. So it's not a good situation for the employer. We also have something called negligent misrepresentation, which is different than fraud because it doesn't have that intent to falsify or reckless disregard element. This one, under the fraud theory, very likely punitive damages might be available. Under the negligent misrepresentation, whenever you see the word negligent, typically punitive damages are not available. And here, it's just a case where the interviewer should have known better, but he honestly didn't. Silence actually can constitute misrepresentation. So let's say the candidate says something like this. Well, I assume if I go to work for your company, I'll earn about $15 an hour. That's what the market is right now. Does that sound about right? And I don't say anything. Maybe I nod my head, maybe I just sit there. Oh, okay, well, I guess that does sound right in your opinion. So anyway, so if I come to work for you, I earn about $15 an hour. In that situation, my silence was kind of a tacit agreement with it. So let's consider this scenario. Bob works as a financial analyst, and when he applies for the job, he's told that in the first 3 months he won't be eligible for any incentives, but once the 3 months are up, he'll be considered a permanent employee. He'll get a raise of 10%, and he will start getting some financial incentives. Okay, so Bob does everything he's supposed to during that 3-month period of time, and yet he isn't designated a permanent employee. He doesn't get his raise, and he doesn't start getting incentives. Even 5 months in, I guess it shouldn't be her, it should be him. Sorry about that. Even 5 months in to the job, he still hasn't been given those perks. So he would be able to sue for the lost 10% wages that he has experienced over the last 2 months and any incentives that he should have earned. Because even if it's negligent misrepresentation, he's still entitled to a make-whole remedy. Obviously, we can have a breach of contract situation. Contracts where you are made certain promises and those promises are not fulfilled. Obviously, if you have a written contract, breach of contract and by the way, here's I guess a term we want to define. And this is our definition for breach of contract, just for your Quizlet information. If it's not a written contract, a breach of contract claim that is oral is not very likely to be successful in Texas because the assumption is going to be that the person is employed at will. And it's very hard to have a breach of contract claim when you're employed at will. Let's consider statements by employees. Obviously, they are interested in being careful during the recruitment process because they want a job, or at least they want to be able to consider the job. Applicants obviously shouldn't make false statements. They shouldn't have false statements on their application, on their resume, on their LinkedIn website. They shouldn't make false statements during their interviews. In fact, if they do make false statements, and let's say the employer finds out about it before the employer makes a hiring decision, that fact alone is enough for the employer not to consider them any further. Even if they are on paper with all the true information, the best candidate, the employer can say, well, we don't want to hire somebody who lacks integrity. Even though the person we hired instead has less qualifications, that person didn't lie to us, at least as far as we know. So a no falsification policy, which is extremely common, is almost always going to be no problem with enforcement. Well, usually the way this happens, or how I've seen it happen, is that the candidate is hired despite the misrepresentations of the application resume, and then at some later time, the discrepancies are revealed. And so at that time, the employer wants to sever the employment relationship. Again, as long as the employer is consistent and always dismisses when there's a material falsification, then the employer has that approach, or can use that approach. Many times this comes up in a situation wherein the employee has already been dismissed for reason A. Maybe it was a layoff, maybe there were some performance issues, and then that employee has decided to file a lawsuit. And through the discovery process, through the time where you're exchanging information, the employee has to share information about his case with the employer has to share information about its case with the employee. Anyway, through the discovery process, the employer oftentimes finds out additional information about the employee. Things that nobody thought to ask when they were hiring this particular employee. And so what happens from time to time is that the employer can learn that the employee made material misrepresentations in its application. And we call this information after acquired evidence. And so the employer says, well, as soon as we found out that the employee actually never did get his bachelor's degree, he attended UNT, but he never completed his degree, even though he said he did on his resume. Well, he lied, and so therefore, even if why we fired him isn't legitimate, we would fire him now because he lied on his application. And generally, that is upheld as a legitimate reason for termination. What courts will say, though, is that, well, you didn't know about the resume lie until the discovery process. So maybe you fired him on January 1st, 2021, but you didn't find out about the application lie until you were through the discovery process on June 1st, 2022, a year and a half later. And so you still potentially owe this worker a year and a half of pay if he's right that he shouldn't have been fired in the first place. Yes, on the date that you got the information about the misrepresentation of the application, June 1st, 2022, on that date you're eligible to fire him, but not before then. So that's how the after acquired evidence argument works. So it can limit damages, but it usually doesn't make all of the damages go away. So at this point, we have covered and finished the topic of recruitment of appropriate candidates. In our next several sessions, we'll talk about the topic of testing. You may think about Dothard here, that case we talked about in an earlier module. We'll talk about hiring, both making the decision and how we communicate and implement the decision. We'll talk about the process of performance appraisals and the disciplinary process, and of course, unfortunately, the end of the employment relationship, which is termination. So we'll be covering those in future lectures. As always, if you have questions, feel free to pop into my office. I'll be delighted to talk with you about them. I hope that this information has been helpful for you. I hope you have a wonderful day. Take care.